Hello and welcome to another episode of Law and Order on a Friday evening. The program each week highlights an area of law and talks to an expert who can give you the best information and advice on that area of law. Today, I have an expert, once again, on an area of law which is important to you, any of you who is in any business or who's forming a company or who's having a company or who is wanting to go into a business with a company. Yes, we are going to talk today on the subject of company law, and none other than to talk on this subject is our guest today is Dr. Harsha Cabral, President's Counsel. Dr. Harsha Cabral, thank you very much for taking time off and accepting our invitation and joining the program. How are you today?
Thank you for the invitation. Thanks, Chanakya.
Yeah. Let's start off with the very basic question. What is company law?
Well, when you take company law, the basic thing is the law that governs companies. Say if you take a human being, say from birth to death, that is the life cycle of a human being.
Yeah.
So you have the birth certificate and the death certificate. So what happens in between is the life cycle of a human being. In the same way, in a company, you have the certificate of incorporation and then the certificate striking off as a company. So this can be 50 years, 100 years, 10 years, whatever. So what transpires in between from the certificate of incorporation until the company is wound up is company law. So it can cover various areas. The incorporation of a company, then you have the shares being issued, then the shareholders, then you appoint a board of directors to run the company, then you have various other transactions of the company with the world at large, the contracts, then you have meetings, you have shareholder meetings, you have board meetings, you have the annual general meeting, you have so many transactions that take place. And then finally it comes to winding up of the company. So when the company has no proper funds to go on, lack of oxygen, then the company has to be wound up. Now, what happens in between? Maybe if I were to teach law to the LLB or the LLM students, I would take maybe 12 months to cover this area. Say 1 month for incorporation, 1 month for shares, 1 month for meetings, 1 month for resolutions, 1 month for winding up, so on and so forth. So the entire law of companies is based on that.
Right.
Basically, it covers all transactions of companies.
Right. There are different types of companies, private companies, public companies. Can you explain to us the difference of these companies?
Now, we have the Companies Act of Sri Lanka, which covers the company law of Sri Lanka, which is Companies Act number 7 of 2007, which is now about 10 years old. Now, under our law, you have certain ways where you can do a company. We have the single shareholder companies, we have the private companies, we have the public companies, we have the public listed companies, and then we have the guarantee companies, and those are the 5 grounds, 5 different types of companies you can do business. Now, in addition to that, you can do business in many other ways. Right. For example, you can have a sole proprietorship, individual saying having Borala stores doing business. Now, that won't come under the Companies Act, and Borala stores may not be a corporate entity separate from its individual. So if you want to sue Borala Stores, you'll have to say Mr. Pereira carrying on business under the name, style and firm of Borala Stores. So that's not part of it, but you can do business under that. As long as you pay taxes, have your accounts, you do business. Then you have another way of doing business, which is under partnership. 2 or more people can get together, can form a partnership. And that again won't come under the Companies Act. Now, partnership is again like sole proprietorship, has no legal existence separate from the partners. If you want to sue the partners, you've got to sue all the 5 partners or whatever. So the other companies that come under the Companies Act, the 5 different types I mentioned, would be the entirety of the corporate structure we talk about in Sri Lanka. Now basically, we have, say, single shareholder company is a new creation under the new Companies Act. Well, a single individual can be a sole shareholder and the director and have a company. I mean, it's just a graduation from the sole proprietorship. So then you have the guarantee companies specifically for particular purpose. It may be, for example, most of the NGOs, and if you have a particular reason to have a company, for example, social service, that objective is there. So that's a guarantee company. Then you have the private companies, which may be the smaller companies or family-owned companies. Then you have the public companies, few people get into it. But if the public company is listed, it comes a public listed company, which is a PLC.
Yeah.
Now, those are the three types of main companies we generally look at, and also the unlimited, the guarantee companies, where the Companies Act will cover all its transactions. Now, if you say a private company is fairly simple in operation, but if the company is public, there again it's a fairly detailed operation. But if the company is listed, then you take the public funds, the public have to invest. So therefore, another regulator comes in. Because all these companies I talk about come under the purview of the Registrar General of Companies. Now, he has the total control of all these companies, all lists have to be filed under that. But if the company is listed, if it's a PLC, then it comes under the purview of the securities regime. So when you say the securities regime, you have on top the Securities Exchange Commission, SEC. Under that you have the Colombo Stock Exchange, CSC. Then below that you find the CDS, Central Depository System, where you do the transactions, share trading on the floor. And those three organizations will be the main securities regime. In addition to that, if the company is under a certain other regulator, for example, banks will come under the banking regulator, right? That's the central bank will control bank supervision and non-bank supervision. Then if it's an insurance company, you will have another regulator, that is the insurance regime. So you have the securities regime, you have the banking regime, you have the insurance regime, in addition to the company law. But all and sundry, all these corporate bodies will be controlled by the Companies Act. Now, you see our Companies Act, that is Act number 7 of 2007, which I say is about 10 years old now, has 534 sections, 13 schedules, and 46 forms. So every time you change the directors, change the secretaries, you have to send that form. So from birth to death of the company, it's controlled under the Companies Act. So the Companies Act is there to see proper management of the company, how these transactions take place, and all these are set out very clearly with the proper organization chart.
Right. Now, what was the background to this company law?
Actually, the company law is basically, we got commercial law, as you know, from the British, right? Actually, the birthplace of company law is England.
Yeah.
But over a period of time, it has been outdated in England, and even in England, after they became a member of the European Community, all the EC directives came and took over most of the traditional company law.
Yeah.
So there was nothing, the old traditional company law was not left to be seen, it went out of the window. So in most of the other countries also where they followed the traditional English company law, it was basically a dying area. And across the Atlantic, it was slightly different. Whereas in the Americas, they thought that all companies should be regulated.
Yes.
Right. So that's how the New York Stock Exchange was born. So the earlier concept of company law, the old traditional English law, what we know, is where they think that the companies were governed by decent people. Right. They thought gentlemen control companies, and that's a rare breed nowadays.
Yes.
So across the Atlantic, they thought it in a different way. They thought, no, we got to regulate these companies. So a hybrid was born in the Canadian formula. Towards the in 70s, 80s, we saw in Canada all the experts looking at both the British model, the English model, and the American model, and they came up with a hybrid model in the Canadian formula, which is known as the Canadian formula of corporate law, which is treated as more effective, and that has been followed in countries like Japan, Hong Kong, Singapore, Australia, New Zealand, and a whole lot of developing states, including a couple of countries in Europe, and where there is a mix of regulation and proper governance which has been introduced in the corporate governance sector. So we followed, when we structured our new company law, we looked at we initially started with the New Zealand model, which is again is based on the Canadian formula, and quite a lot of new mechanisms are seen in the process of this company law, which I must say is fairly modern.
Right. Now, in Sri Lanka, you mentioned about the ways, the types of companies we have. That means the ways of doing business. What would be your answer for the question, what would be the best way for a person to do business in Sri Lanka in this existing legal framework of corporate law?
Yeah, depends on what sort of business you want to do. Now, there are so many companies, fairly big companies, which are not listed. Right. So they feel that, well, some feel that when it is listed, maybe the regulation will be more. So you have family companies, you have business companies, you have joint ventures. So depending on the structure of the company, if you want to keep it as a family company within the family, well, you can still run it as a private company. If you still feel that you want to have a single shareholder company, you can do so. And maybe if it's a NGO or social service organization, you might say, well, you have say a guarantee company. So that depends on the legal advice you get, what sort of, the tailor-made model for your company and how. So when you're incorporating a company, you should see what are the best mechanisms. Now, say there are certain lenient procedures adopted under the Companies Act for private companies. But if it's listed, now the idea is when a company is listed, you try to borrow funds from the public. So there should be regulation, like in banks. Most of the banks are on the public money. So the depositors, more than the shareholders' funds, it's the depositors' money. So there you should have a proper regulator. So that's why I mentioned the regulation is important. But all in all, the Companies Act itself provides for proper governance. So that is where you have the maintenance of company in a different way, and then the securities regime coming in, and the role of shareholders, role of directors, role of the company secretary, role of the auditor, so on and so forth.
Right. Now, do you think it depends on the trade or the business area that you should choose what company to go into?
Not really. It's not really the trade that is involved. But if it's banking, well, you're compelled to come under the securities regime plus the banking regulations from the central bank. That's why I mentioned you have the bank supervision and unbanked supervision controlled by the central bank, which is fairly rigid and very strong regulation there. Whereas if it's say a company that is manufacturing garments, well, they can decide whether it's not necessary for them to list it for under the public listing, or they can go on as a private company.
Right. Now, we have the stock exchange, like you mentioned about New York, we have the Securities Exchange Commission. Now, under our law, the shareholders, how protected are our shareholders under our law?
Yeah, that's a very good question, because under the Companies Act, there is a mechanism to look after the shareholders, whether majority or minority, both. Now, the most common provision we use as lawyers for the protection of the minority shareholders is the oppression and mismanagement remedy, which is set out in sections 224 and 225 of the Companies Act, where if you have a shareholding of more than 5%, or if you can muster adequate support of 5%, you can go to court and get your remedies, say if you can ask for interim relief also in addition. And so those are the most commonest remedies for oppression and mismanagement. But in addition, you have under section 233 a new remedy called the derivative action. That again, you don't need 5% threshold. If you can establish there is fraud and wrongdoer control, you can go to court, and with the leave of court, you can get certain remedies. So there are provisions available under the Companies Act where interim relief can be sought. So sort of you can obtain a stay order under 230. You can get a stay order. You can get an interim relief, and also you can get under 521. Interim orders from the company under the Companies Act. So these are the mechanisms that are available to the minority shareholders. In addition to that, there are several remedies for the shareholders, because if the directors don't act properly, if they breach the provisions of the articles, if they breach the provisions of the Companies Act, the adequate remedy is provided, because now, specifically under the new Act, the directors' duties and responsibilities are very, very detailed. It has been set out in black and white under sections 187, 188, 189, then from sections 191 to 200, conflict of interests with in share transactions, conflict of interest in contracts. Then specifically 187 says the director should act in the best interests of the company, and how the genuine bona fide actions of a director is expected, not to act in a reckless manner, not to act in a negligent manner, the standard of care that is expected, how we should not breach the provisions of the Companies Act and the articles of association. So there is a proper balance. In addition to that, there is financial management has been streamlined. There is solvency test. These are all new features which have gone into the Act. So proper financial management is crucial for the maintenance of a good company. So if the solvency test, if I always call the golden thread that runs into the entire fabric of company law, where the director should maintain that the company is solvent at all given moments. So there are enough and more mechanisms. Then you have additional features like the administrator role, the winding up mechanisms, then the disputes board that has been introduced. So all in all, you can see that there are several mechanisms for the shareholders to look after their interests, and even the creditors have adequate protection under the provisions that are available under the Companies Act.
Right. Now, there's another concept under the, it may be not in the Act, on all companies, on business, called corporate governance. Explain to us what exactly is a corporate governance. Is it a legal requirement? Is it some kind of a business thinking? Or how does it work?
Yeah, corporate governance is, you know, the words corporate governance would not appear anywhere in the Companies Act. If you look at the 534 sections or the 13 schedules or the 46 forms, you will not see the words corporate governance there. Now, the birth of corporate governance goes back to the early 90s, in 1992 in England, where Sir Adrian Cadbury, the Cadbury Code of Best Corporate Governance, the Code of Best Practice, was created in England. Thereafter, from 97, we have also started our own, with the assistance of Institute of Chartered Accountants, the Code of Best Practice. So corporate governance is proper governance, right? Transparency in governance, good governance. I mean, now you have Vihapalanaya, so I mean, these are words which came up later in the day. So proper governance means, now this again is, right now it's restricted only to listed companies. Now, under the securities regime, you find in the SEC rules mandatory code. Now that is very, very minimal. What is introduced under the securities regime is that all listed companies should have X amount of independent non-executive directors on their board. And also you must have audit committee, remuneration committee, and so on and so forth. So in addition to that, we have a very, very wide voluntary code. If you go into the SEC web page, you can get that voluntary code. Most of the companies follow, I must say the listed companies follow. But like if I say corporate governance is something like that comes from your own heart, you see. Whether you're a good boy, you follow the 10 Commandments or so and so. So the word corporate governance is to see that this is good governance and the company is a good corporate citizen. All functions of the company carried out in a very, very transparent manner, so that corporate governance ultimately looks after the shareholders of the company itself, the employees, the creditors, and all the other stakeholders, and also the world at large. That is why the extreme end of corporate governance is CSR, corporate social responsibility. You would do something totally different to what you're doing. I mean, you're in the manufacturing field, but we will be we will be doing something more for tsunami relief, or a whole lot of corporate social responsibility mechanisms. So corporate governance is something beyond corporate law. And that again in Sri Lanka, it's only, right now it's limited only to the listed companies, but any company is free to follow the mechanisms of corporate governance.
Okay. Now, you were, if I may say, a kind of architect in the last Company Act of 2007.
I won't call myself the architect. I was one of the architects in the team which did this.
Now it's time tested for about 10 years. What are the changes you would like to see in the Company act, not only the act per se, in the company law in Sri Lanka, or are you happy with the existing system?
Right now, there are a few amendments which are in the pipeline, which will become law very soon, because there are a couple of hiccups in the introduction with regard to the translations, right? Now, for example, winding up section, what we intended was inability to pay debts to be 50,000. Earlier it was 500. So we have increased it to 50,000. But unfortunately, in the singular version, it has gone as 5,000.
Yes.
So by practice in the Commercial High Court, we have agreed that it is 50,000. The single English translations and spellings and whatever. But in addition, this company re-registration, I believe section 489 or whatever, has been corrected to say that an application can be made to the Commercial High Court if you want to get the company re-registered. That amendment will come in due course, because there are a whole lot of companies which were not registered, re-registered. And the law says, as it is, that the assets, if any, would vest in the state. But since it did not happen, so the parties will be free to make an application to the Commercial High Court if they want to get the company re-registered. But that is in the amendment that is seen. So there are few mechanisms are brought in the new act. I must say that overall there are no major changes or major amendments that I can foresee for the time being, because anyway now 10 years time, it's high time there will be a couple of amendments, and unfortunately the new provisions have not been tested yet. Most of the sections have not been tested yet, so in the time to come I suppose the newer mechanisms will have to be tested.
Dr. Harsha Cabral, thank you very much for joining Law and Order, and thank you for those very detailed and insightful thoughts on the company and corporate law of Sri Lanka, and thank you for joining us.
Thank you very much. My pleasure.
Luck and success for whatever you do in the future. That's Law and Order for you today. Join us on our Facebook page. It's facebook.com/Law and Order Channel I, and join the conversation. You can send us your suggestions, your comments, or whatever you'll have to say about the programs and what you'd like to see on the programs, or your questions on law to that Facebook site, and we will definitely take them into notice in our future programs. I'll see you next week at the same time with another program on Law and Order. Enjoy the rest of the programming on Channel I. Have a good night and a good weekend.